Doesn't it depend on exactly what they're doing? I mean, I guess the hard part for me is really trying to understand how we apply this analysis at the broad level of generality that I think both sides seem to be taking here. I mean, you say what is being regulated here is conduct, not speech. Well, I guess maybe if you're talking about Facebook's news feed feature, but there are lots of other things that Facebook does that, that might be speech, but then there might be other things that Facebook does that doesn't qualify as speech. So don't we have to drill down more in order to really figure out whether or not things are protected?
Actually, I don't think so. I think that precise ambiguity strongly favors our position, Your Honor, because in the posture of this facial challenge, all you need to look at is whether there are at least some activities.
No, but that's no. I guess what I'm saying is you mentioned the Pruneyard case, or the Fair case, excuse me. I mean, we didn't say that law schools, as a categorical matter, are, always engaged in unprotected speech. We looked at the particular thing. This was a fair. And, the law school was saying we don't want these certain entities in it. I hear you suggesting that we can just say, Facebook is a common carrier and therefore everything it does qualifies as conduct and not speech. And I don't think that's really the way we've done this in our past precedents. So can you speak to that?
Sure. Certainly that's not what we're saying, Your Honor. I completely agree with you that it's very important to isolate what conduct each particular provision of the law is regulated.
Not the law, the entity. What is the entity doing? We have to do an intersection of what the law says they can't do and what in particular they are doing.
Well,
right?
And I guess the right level of generality and the level of generality that's sufficient, I think, to conclude that the law has a plainly legitimate sweep is we are talking about the social networking companies' activities in content moderating user-uploaded content. That I think is the relevant activity, and that is what All right.
Activity. So what do you do with LinkedIn has a virtual job fair, and it has some rules about who can be involved. That seems to map on, I would think, to the Fair case. Is that what you're saying?
Well, I don't think so. I don't think it would map onto our theory in this case, because it sounds like to me, and I'm not totally aware of all the facts of LinkedIn there, but if I understand.
I think that's a problem in this case. We're not all aware of the facts.
Well, exactly, and I think that is one of the reasons why this facial challenge has been very confusing to defend, because we kind of don't know what to defend against.